We recommence with the point raised by Dean of Law and former magistrate David Halpern, which qualifies as one of the few accurate statements he made in the video clip shown, that there are people who are selling what might be termed kits, which purport to inform people of various processes and statements they could make to try to evade having to comply with much of the legislation and thus avoid the payment of fines and penalties involved with the breaches of such. He also states that every level of court gives very short shrift to the arguments presented by the deliberately misnamed sovereign citizens who are foolhardy enough to try to beat the corrupt legalese system at their own game. There are various videos and stories available online which claim to show successful outcomes from the defendant's points of view. But it's a risk which is certainly not worth taking for anyone with some understanding of constitutional law. There is an excellent unpicking of the type of psychology-based wording and body language used in media pieces such as these, available on the MC 1215 Knowledge Centre AU channel on Telegram, so I won't waste time by repeating that here, but it's well worth a look. It's also referenced on Fitzroy Sterling's Soundbite University videos on Facebook. Here is another example of a media hit piece on this topic, with the links to both of these clips included in the comments box. At the 50-second mark, we see Police Commissioner Luke Cornelius referring to those who question the validity of legislation as the tinfoil hat brigade. This might be an argument with some weight, were it not for the existence of a constitution, which does, of course, provide accurately prescribed restrictions on what any parliament can enact into legislation. Any subject worth their salt is perfectly entitled to discover government or any of its agents overstepping the marks of the Constitution and calling such to account. However, as long as the vast majority of people are too uninformed or too lazy to research and know their rights and the limits within which government is supposed to be confined, they tend to go along with this pejorative ridiculing of those who have the courage to stand on principle. This series of videos has taken the time to explain the constitutional position regarding our current duplicitous administration. But as David Halpern says, the issues have become very confused, aided by the insertion of numerous groups espousing various concepts of the topic of common law. Charles O'Neill has produced 2 excellent essays on the subject, the links below, in which he raises the question of whether the proliferation of so many voices might well be not just due to faulty understanding of the Constitution, but also to the planned efforts of those running our scam governments to splinter the opposing movement and thus blunt the point of its jousting lance. The issue here is not about whether one can beat the system or get off from a fine, but whether the system of law and government we have is based on any form of morality. The hosts state at the 1-minute mark that the protagonists of the sovereign citizen movement argue that they haven't consented to the laws and that this is a requirement for laws to be considered valid. That is true, but not in the sense that this piece displays it. The common law on which the Constitution and Magna Carta is based is indeed consented to by everyone who is not a criminal, because it is based upon the universal code of morality which everyone with a functioning conscience understands and to which they consent. From whence does this wholesale understanding originate? One of the best explanations stems from the great 17th century Dutch philosopher Baruch Spinoza, from his work Ethics. Quote, "There is nothing more useful to a man than a man. Men, I repeat, can wish for nothing more helpful to their staying in existence than that all men should be in such harmony that the minds and bodies of them all would be like one mind and one body, that all together should try as hard as they can to stay in existence, and that all together should seek for themselves the common advantage of all." End quote. Does not this sum up very neatly the basis for common law to which all moral people can subscribe, and do indeed consent? David Halpern states in this second video from the project, at the 2-minute 15-second mark, that those who he terms sovereign citizens seek to evade, quote, "fines and penalties for things which would otherwise be crimes," unquote. This is sloppy definition. Is a parking fine or even a speeding fine or partially crossing a solid white line with one's vehicle evidence of a crime? Where is the victim? Of course, if such actions result in harm or loss to another person, then there is a victim and a case to answer. But if not? Both Halpern and the hosts know that almost everyone has been conditioned over their lifetimes, as have preceding generations, to accept that such actions do constitute crimes, but the Constitution has a different definition. Section 39 of Magna Carta 1215 states, quote, "No free man shall be seized or imprisoned, or stripped of his rights or possessions, or outlawed or exiled, or deprived of his standing in any other way, nor will we proceed with force against him, or send others to do so, except by the lawful judgment of his equals or by the law of the land." End quote. This plainly stipulates that no summary action shall be taken against anyone unless and until they have been tried by their peers, in other words, a jury of their equals, according to the law of the land, in other words, the common law, which is accepted by all. Jurors in this situation have to consider the intention of the accused, and if there is no intended malice or outcome, to acquit, probably with a warning lest actual damage ensues from a later event. Where exactly does a magistrate's court or a magistrate fit into that scenario? Is every subject regarded as the equal before the law of a magistrate? Either way, how does the magistrate get to inflict summary justice upon people for infractions of legislation which may not have been tested for constitutional validity in clear violation of Section 39, which has never been, indeed never can be, repealed by Parliament? David Halpern, on his own admission, operated for 22 years as an inflictor of arbitrary and summary judgment, often involving punishment or deprivation of a subject's clear constitutional right to freedom from such injustices. No doubt he will be able to quote Acts of Parliament, probably any number of them, which it purport to give him this authority. But if such acts or statutes are repugnant to the Constitution as laid down in Magna Carta, they are invalid, and assuredly call into question his credentials and actions as a dependable expositor of law. Naturally, the hosts in the video clip aren't concerned with such niceties, and they further demonstrate this from about the 3-minute mark, when they ask David Halpern if he would defend someone making a sovereign citizen argument as a lawyer in a courtroom. His explanation as to why he would not skips around the question of whether there could actually be a lawful objection to the charge which the defendant is facing. Instead, he attempts to put an honourable face on it by stating that he couldn't, as a reputable lawyer, engage in such a losing proposition on behalf of his trusting client. Is he aware of the constitutional realities of the situation, indeed of the invocation of Article 61, with all its implications for the bastardry of the legalese process he is defending? We are not going to find out from watching these types of video clips, are we? The TV hosts have an agenda to promote with their piece, and David Halpern certainly benefits, at least temporarily, from the continuation of that promotion. Assuming that David Halpern does know of Magna Carta, that it is still in effect despite the machinations of centuries of legalism and of the invocation of Article 61, he could have said something like this, quote, "Well, of course, those people pursuing their sovereign citizen arguments aren't going to get anywhere stepping into our corporate courts, which don't have Crown authority, but there is actually a constitutional process whereby they don't have to fight us on our own ground or even step into our courts, but can reduce us to a state where the only actions we can take against them are unlawful and for which we can be tried before a jury," end quote. Sadly, like the courts which operate only under the colour of law but without lawful authority, he only has to answer the questions he is asked, not the unspoken ones which would reveal the truth. He does, however, let slip the information at the 3-minute 40 mark that Australia is a corporate state to which everyone, according to him, has to pay obeisance. I challenge David Halpern to state the legitimate constitutional action which transformed the Crown from its role as an independent authority charged with defending the realm and the rights and liberties of the subjects into a corporation, one with the authority to empower those administering it to milk the subjects of their freedoms and wealth for the benefit of said corporation. Oh, and the date, please, David. Finally, we come to the question of the behaviour of police under this corporate system of government which has been so graciously bestowed upon us. When police are trained, they swear an oath or affirmation, certainly very similar to this one displayed. Quote, "I do solemnly, sincerely and truly declare and affirm that I will well and truly serve our Sovereign the King as a police officer, without favour or affection, malice or ill will, until I am legally discharged, that I will see and cause His Majesty's peace to be kept and preserved, and that I will prevent to the best of my power all offences against that peace, and that while I continue to be a police officer, I will, to the best of my skill and knowledge, discharge all the duties thereof faithfully according to law." End quote. It is difficult to see how a police officer enforcing unlawful mandates or legislation, or for instance violently ripping car windows from vehicles, can be said to be honouring their oath to, quote, "preserve and keep His Majesty's peace, and prevent to the best of my power all offences against that peace," end quote. Which oath are they honouring? The one made as an ostensible public servant, or the one made to the corporation employing them? It's a question every law-abiding subject has every right to ask. It is our responsibility as sovereign subjects, who swear with a clear understanding of our duty to comply with the law, as opposed to invalid legislation, to expose to as many people as possible the existence of our Constitution and the power it gives to subjects to call to account not only the administrators of justice, but the very acts of legislation themselves through the power of the jury. Next time, we'll be concluding this series within a series by expanding on the concept of countering this fake sovereign citizen catcall by informing more of the general population of their true identity as sovereign subjects and the powers granted to them by our long-standing constitution as laid down in Magna Carta. Great work has been done on this for years by people like William Keat, who recently, along with historian Neil Oliver, has risen to prominence with some timely interviews online. Thank you for watching.